been working? Yeah. My voice is always so loud that I probably don't need the mic, but I'll use it anyway. I think I can now say good evening. I never know. It's 5:35, so I can't say good evening. We could take a linguistic poll and find out how many people say good evening at 5 and how many people wait till 6. In any case, I'm Mark Aronoff. I'm Distinguished Professor of Linguistics and Senior Advisor to the Provost, or as I prefer to be called, Consigliere. On behalf of Provost Kaler, it is my distinct honor and pleasure to welcome you all to a lecture by Hendrik Hartog, whose title, Class of 1912 Bicentennial Professor in the History of American Law and Liberty at Princeton, is even better than mine. Professor Hartog holds a PhD and a JD, making him both a doctor and a lawyer, which means he counts double, at least in my family, so don't tell my mother about this guy. He has spent his scholarly life tracing the ways in which the history of American law has expressed social, political, and cultural history. I'm sure, for example, that he would be able to help us to understand the decision of the Federal Department of Justice in the last few days not to defend the Defense of Marriage Act, but maybe we can ask about that during the question period. Today, he will talk about his current project on inheritance conflicts a century or more ago, and show how these legal wrangles shed light on a surprising variety of important aspects of life in this country and especially in this region at that time. We'll have time for questions after the lecture. Please join me, though, in welcoming a great friend of Stony Brook University, Hendrik Hartog.
If I can get out, I'll be... Thank you very much.
Thank you.
I lost a page already. That's wonderful. Thank you all very much. It's really a great pleasure to be here. Well, I'm just going to start reading from this talk, which actually is partly drawn from a book I've just finished, which is coming out next year. Can you hear me okay? Okay, thank you. Okay, thank you. In the early 1990s, my sister Vivien Hartog was a graduate student in sociology and women's studies here at SUNY Stony Brook. Those were both the last years of her life, for she died too soon in 1995, and also, best I can tell, her happiest years. For the pleasures and satisfactions that my sister experienced as a doctoral student, I'm very grateful to all of you. At that time, at Stony Brook and elsewhere, including the University of Wisconsin Law School, where I then taught, two intertwined perspectives about care shaped a great deal of work in feminist and feminist-inspired legal and political thought. One perspective had to do with how to conceptualize the uncompensated labors of women, usually as wives and mothers, within households. And that perspective was also often reformulated with a sharper focus on the politics of caretaking. That is, on how to formulate a public duty to pay for care for the dependent and the disabled. How to pay for the care provided by usually uncompensated and almost always undercompensated women. The second perspective, on the other hand, developed a critique of the insistent commodification of many kinds of labor, including household labor. The first perspective argued that much done apparently out of love should actually be recognized as work and therefore should be paid for. The second perspective argued that much in the world ought to be understood as done out of love, not as contracted for and commodified labor. The first perspective is strongly identified with the work of the distinguished Stony Brook philosopher Eva Katay, whose seminar my sister attended enthusiastically and from whom she learned much, as well as with that of my former colleague at Wisconsin, Martha Feynman. The latter perspective can be identified with, among others, the writings of the legal theorist Margaret Jane Radin. My sister and I talked and argued for many hours about these questions and perspectives. They had immense personal significance for her. She had raised 3 sons, mostly by herself. She had been married 3 times and then had numbers of other relationships. She had led a very complicated and often unhappy familial life, including many years in a cult. There were times in her life when she thought of herself as a businesswoman, and later on she loved teaching at Stony Brook. But she was almost never adequately compensated for the work she engaged in. By the mid-1980s, she had left the cult and she had begun a new life, first working in Hawaii for a hotel where she managed housekeeping services. Then, already well into her 40s, she returned to college at the University of California at Santa Cruz. While there, with her sons out of the house, she supported herself working as a home health care worker, caring for very elderly clients. Then, after receiving a bachelor's degree, she came to SUNY Stony Brook to pursue doctoral work. Several years after Vivien died, after a period when I too was immersed in the practicalities of caretaking, I returned to the questions we had argued about as I began to explore a database of New Jersey cases involving suits for compensation by caretaking children and other family members. These were wonderful in the particular way that cases can be, at least for a historian, as they incorporated both all the theoretical and moral and political questions that my sister and I talked about, as well as a great deal of grungy and fascinating, really grungy, you'll see some of that later on as I go, detail about the work of care. The talk that follows, then, is dedicated to the memory of my sister and to the Women's Studies program here that inspired and sustained her. My goal is to sketch lightly how the kinds of arguments that seemed new and novel in the law schools and in the women's studies programs and in the sociology departments of the early 1990s can be found in the routine discourses of the courts in late 19th and early 20th century inheritance cases. I don't mean to claim that perspectives and understandings have not changed, but I do want to historicize and challenge the notion that in the 1990s we were talking in dramatically novel ways about new phenomena. So I'm doing what historians often do, revealing a longer and more complicated story, challenging our conventional wisdom that our world and our understanding of the world are wholly new. And along the way, I think I tell some interesting and peculiarly graphic stories about family work and how it was talked about in the generations before our own. So the talk will move through 4 acts or sections. There's an introduction or an opening that deals with the presumptions, the legal and cultural norms, what today are usually called default rules that shaped the law of family work around the middle of the 19th century. I then offer a quick riff on the problem of what it means legally to be a member of a household as an adult child, as of the second half of the 19th century. I then offer a longer exploration of the ways early 20th century courts reformulated the identity of an adult child within a household. And finally, I finish by suggesting how, by the middle of the 20th century, labor within the home by adult family members gradually came to be understood as exceptional and unexpected and therefore deserving of pay. Okay. Everywhere in 19th and early 20th century America, after older people had died, adult children sued the estates left by those older people for unpaid wages. It happens everywhere, in every jurisdiction. Those adult children, daughters and sons, as well as grandchildren, adopted children, relatives distant and close, as well as unrelated individuals, brought actions quantum meruit, literally actions for as much as he or she deserves. From the perspective of those adult children, a suit for unpaid wages would often have been understood as a second-best alternative. What many of them had really wanted, the better alternative, was land or other property. That was usually what they'd been working for, but it was not easy to turn labor in the home into a successful, that is, a judicially recognizable claim to property. What they would have to settle for, what they often would have learned from lawyers, was all they could get, if that was a cash equivalent for back wages. In the trials that resulted, courts heard testimony about promises made and negotiations and wills drafted and changed and foregone opportunities elsewhere, and they heard much about quantities of work and care. but there was almost never a written contract put into the record. Written contracts, just as today, were not an ordinary part of family life and of the negotiations that went on between family members. All that judges and juries had to go on were narratives about work done and explanations or reasons why people had worked. Now, what were those narratives supposed to prove? What was the evidentiary significance of work in the absence of a written contract? By the middle of the 19th century, such questions had a direct legal answer in most labor contexts. At least for free American adults who worked outside the home, work presumed a right to compensation. Or to put it somewhat more legalistically, quote, when one was employed in the service of another for any period of time, the law implied a contract of hiring and promise to pay. A worker had a right to be paid for work actually done. When services were rendered, the recipient or beneficiary of those services, the employer, became obligated to pay. Not to pay would be a form of unjust enrichment, of fraud. The law presumed that no one volunteered their labor. And if the employer had not paid for the work actually completed, the employer was liable for an action quantum meruit. Was that true within a family? Was that true for the kinds of work that adult children did within the households of parents and other older relatives? Here, a second default rule qualified or limited the initial answer. Again, I'm quoting. An agreement to pay for services rendered and accepted is presumed unless the parties are members of the same family or near relatives. It's the default rule. As a New Jersey judge put it in a much-cited 1860 case, the law implies no promise to pay for services rendered by members of a family to each other, and he concluded that authorities for this proposition were so numerous that there was no need for any particular citations. This qualification was presented as if it was an expression of simple common sense. Family work meant non-compensable work, done for reasons other than expectations of pay. One family member could, if she or he wished, pay for another family member, but not to pay for work completed or for services rendered did not imply the existence of an unpaid obligation or a debt unsatisfied. Work done in the home did not suggest the presence of an underlying contract for wages. When someone worked anywhere but at home, the inference, both culturally and legally, was that the work would not have occurred but for the expectation of pay, so long as the someone was a competent and free adult. Obviously, race, slavery, whiteness, there's a lot of things that would qualify it, but in the sort of straight-ahead legal definition, work meant pay. Why would one labor for a stranger except because of the promise of compensation? By contrast, when someone worked at home, although what was at home could include on the farm or in the shop, as well as in the bedroom and kitchen of the house, the presumption, again, both culturally and legally, was that the work came about because of desires and obligations distinctive to family life. After all, there were so many culturally significant reasons involving love, duty, sharing, investment in the future that explained why one might have worked at home without the expectation of pay. Judges and lawyers and litigants alike regularly sang familiar, sentimental songs about the distinctiveness and the significance of the loving home in a variety of keys and registers. They knew, as all competent participants in the legal culture knew, that the work that made a home differed ontologically from commodified labor given and received by strangers. Outside of the home was where a judicially enforced contract law held sway. In the home, reciprocity, care, love, and duty shaped the commitments that came with intimate relationships. How then to adjudicate the claim to compensation of an adult child, the son or daughter or other relation who had remained at home even though he or she could have left to pursue opportunities elsewhere? Was the adult child still at his or her home? The adult child was not in a legal relationship of dependency. The adult child might well have his or her own family, that is, children and a spouse. In a society founded on mobility, where sons and daughters routinely moved away from their parents' homes when they became adults, what did it mean when they hadn't? Or when they returned to the parental household after a period of time away? Had home become presumptively a place of employment, with parents as employers, or did home remain home, in which labor occurred for reasons other than the expectation of wages? The starting point for any legal analysis of these questions was that to be an adult child meant that one carried no legally enforceable duties towards one's parents. This is a distinctive feature of Anglo-American law. Children surely often, perhaps usually, felt obliged to care for those who had once cared for them. In theory, but almost never in practice, a town or other local government could require compensation from children if a parent were put on poor relief. But parents had no legal rights in the labor or care or the cash of their non-minor children. What then of the adult child who sued a parent or a parental estate for unpaid wages? Such suits produced a continuing conversation between judges and lawyers and litigants about the nature of the adult child. As an adult, that is, as a competent individual who might be either a worker or someone who had given the gift of care, and as a child, that is, as someone who continued to belong to a family or to a family member. Hard, almost metaphysically hard questions about freedom and care and duty emerged out of these easy, trivial, and common situations. What was adulthood? What did it mean to be in the family? What were exceptional tasks that would not have been undertaken but for the expectation of compensation? And what were voluntary undertakings? Did a voluntary undertaking apply in its nature an underlying contract? Or was a voluntary undertaking in its nature a gift? When an adult child took care of an older person, was it work? That is, was it free labor? Or was the older person in his or her estate freed of the obligation to pay? That is, was it free labor of a different sort? Here is how L. DeWitt Taylor, a lawyer representing an intestate estate in an 1886 lawsuit, challenged the claim of a daughter in her mid-40s that she was entitled to be paid $3,000 on a note her now-dead mother had given her. The note was meant as payment for her care. But according to Taylor, if obtained under the pretext that it was for services rendered by the daughter to the mother, it was void, because the daughter never rendered any services to the mother, but such as it was her duty to render in the position she occupied in her mother's house. That she was unmarried and unemancipated, that she and her mother stood to each other in the relation of parent and child, that there was no express contract ever made between them, and that she could therefore receive nothing. That she was fed and nourished at her mother's table, that she was clothed and cared for at her mother's expense, that she was in feeble health a good deal of the time and required the attendance of a physician for whose services the mother paid. In short, that the benefit she received from her mother greatly overbalanced any services she rendered. Now, the key word in Taylor's argument in that paragraph was unemancipated. This was a term with a long and tortuous history, a term only loosely connected to the post-Civil War understandings that built from abolitionism, from the Emancipation Proclamation, and from the 13th and 14th Amendments, and a history totally distinct from the emancipations we identify with the 1960s. For Taylor and his audience of judges, emancipation defined the boundary between childish dependence and adult responsibility and independence. The middle-aged daughter, who he argued did not deserve the money she had apparently been promised, remained a daughter, a child, who lived in her parents' house effectively as a dependent. And thus, he insisted, she should not be paid. Now, for us, the boundary between childhood and adulthood may be marked by a variety of events and transformations. The right to vote, military service, sexual maturity, wages, living on one's own, freedom from the authority of a parent, perhaps marriage. For both parents and children, the crossing of that boundary can be experienced as emancipatory. Children are freed from the supervisory authority of parents, while parents may understand themselves as emancipated from duties of support. But for us, that boundary is fundamentally all about chronological age, about a birthday celebrated, about an age of majority. though we still talk as if there's a vaguer but knowable psychological or cultural moment. In the 19th century, chronological age, a birth date that marked the end of minority, was important as well. A father or mother could not demand that a child who had turned 21 remain to serve and care. At 14 or 16 or 18, depending on changing laws and mores, a father or mother could no longer stop his or her child from marrying. The daughter in the 1886 case in which L. DeWitt Taylor made his argument could have emancipated herself at any time by marrying or by leaving home, even before reaching the age of 21. In fact, and it's important to note, in the end, the court rejected Taylor's claim that she was unemancipated. The court's opinion insisted that the note the mother had given her daughter constituted a just debt against the estate. The services that the daughter had rendered over the many years since she had become of age justified it. But Taylor's language, as well as the court opinion, also carried the residual traces of a notion of emancipation that was functional. That is, about how and with whom one lived, rather than formal or objective. That is, about having passed a particular age. And this notion was rooted in a much longer legal history. That notion, it's obviously tied to patriarchy and to the foundation of emancipation as a legal category lay in archaic understandings of patriarchal power. A father always had the right to emancipate his son at any age, in the same way he had the right to open a cage and allow a pet bird to fly away, but he had no duty to do so. Emancipate was something done or not done to a subordinate, sons and daughters as well as foster and adopted children and apprentices, as an act of power and as an expression of a possessory right. Early on, it overlapped with notions of manumission, the right of a master to free his slaves. Over many centuries, the older notion of emancipation had grown muted, even as it remained a presence in the law. Emancipation had become the naturally attainable state of having come of age. It constituted an ending to paternal power, and fathers and guardians could not retain permanent power over their adult children. Yet all that, and there's much more to be said about that, but yet did that mean that a 19th century adult child who remained within a parent's house, who had never left, was necessarily emancipated? It was all a matter of presumptions. Absent evidence to the contrary, absent evidence that the relationship between a parent and a child had become a business-like one, a child who remained in the household presumptively remained an unemancipated child, whatever his or her chronological age. In theory, it was easy to overcome the presumption. There were lots of facts that you could raise, like, I'm earning a living or doing other things that would change it. But if nothing had changed in the work or marital lives of children, they remained children in the household, whatever their chronological age. And in that case, they would not be likely to succeed if they later sued to be compensated for services rendered in parental households. Now, obviously, in determining the force of such presumptions, gender conventions played a really powerful role. Young men who gave up opportunities away from home in a free labor market to return or to stay at home were often recognized as presumptively entering into a contractual work relationship with parents. The presumption that a child remained a child within a parental household was easily overcome for such men, less often for young women. As one judge wrote, the female children of many parents often remain unemancipated long after attaining majority, rendering services to the father and supported by him. For such services, there would not be a right to compensation. Putting off marriage, for example, by a young woman was not understood by the courts as equivalent to a young man deciding to go away to do for himself in the work world. Even when a young woman went away to work or to pursue a career, as young men did, and then returned, her departure might not be enough to secure her emancipation. For example, in Gardner's Administrator versus Schooley, a young woman, Sarah A. Schooley, had gone off to learn a trade. She stayed away from home for 3 months. Then her mother's illness and eventual death made it necessary for her to return. Thereafter, she stayed and served in her father's house, where she lived with her brothers. Their father was a day laborer for the railroad, and he possessed a small house on a lot of 1/4 acre. His sons paid no board to him, although they did help furnish the house, nor did they compensate Sarah for the washing and mending that she did for them. And there's nothing in the case to suggest that they rendered any services to their father. Instead, the sons, whom one can read as effectively emancipated, retained all their earnings for their own use. And Sarah served them, as well as their father, in the small house where they all lived. Her father, who had promised her that if his life was spared, he would give her something to show for her services, eventually gave her a mortgage on the property. But when, after his death, creditors challenged the mortgage, the court ruled that she was entitled to nothing. There was no contract between father and daughter. Instead, the gift of the mortgage would, if held valid, have defrauded her father's creditors of their claims. The law would not imply any promise to pay for services rendered by a daughter to a father under such circumstances. Sarah had returned to her father's house while she was yet a minor to live in and be part of his family, and so she continued unemancipated. Now, the point is not that women who remain to care for aged or aging parents never won suits. In 1879, to take one example, a court affirmed the payment of $518 to a late middle-aged Catherine McCone, and she's somewhere in close to 60, I believe, for the care of her very old mother. Her mother was 93 when she died. Her mother had fallen and was permanently lame over the last 5 years of her life. Mother and daughter had always lived together, and Catherine had long taken care of her. She could have been understood as never emancipated, but the court concluded that there was clear evidence that both the mother intended to pay Catherine and that Catherine expected to be compensated. This was not, they held, the routine case of a daughter supported by her mother and rendering service in the household. It was rather one where a daughter provided necessary services to an old and helpless mother, services which would otherwise necessarily have to be provided by a stranger. Since the mother would have had to pay someone, it was reasonable to suppose that she had agreed to pay her daughter. And by the time of this last case, by the end of the 1870s, the historically resonant language of emancipated and unemancipated began to disappear from judicial opinions. It's not surprising then that L. DeWitt Taylor's 1886 argument failed. By then, lawyers who wanted to challenge claims to pay by children and other care workers were looking to a different discourse. What was happening? Perhaps the courts could not resist the increasingly determinative power of age consciousness. It may also be that by the 1870s, inherited and long-standing legal understandings of emancipation and unemancipation were being increasingly difficult to articulate in the face of a constitutional polity now formally committed to universal emancipation. One discourse of emancipation would have overlaid another. The older language of emancipation had carried with it powerful but increasingly archaic patriarchal assumptions. The older language had rested on a belief in what Blackstone had once called the empire of the father, a belief that children ordinarily remained within the private property-like domains of fathers and sometimes of mothers. By the last third of the 19th century, however, a variety of cultural and political forces, including a women's rights movement, the beginnings of a child protection movement, new and expanded invocations of the police power that allowed at least some forms of public and semi-public intervention into the privacy of at least some households, challenged and worked to weaken parental power. As parental power weakened, the utility of the image of an unemancipated adult child apparently weakened as well. The last New Jersey decision that depended on a judgment that an adult child who had worked and cared in the home was unemancipated occurred in 1894. The decision served as the penultimate act in an endless and endlessly complex story about the estate of James Taylor, one of the founders of the Trenton ceramics industry. It's toilet bowls, actually, if you're interested. To simplify the story, The estate was sued by the creditors of Taylor's business partner, Isaac Davis, because Taylor had endorsed Davis's note. After having signed the note, and not long before he died, Taylor had conveyed his large and recently purchased family home on Clinton Street to his granddaughter, Ella F. Severs, who would marry the same much older Isaac Davis after her grandfather's death. The Davises' creditors argued that the conveyance of the home was an attempt to defraud them. Now, by the time of the litigation, Ella F. Severs, the granddaughter, had also died, as had Isaac Davis. But her heirs at law, her siblings, argued that the conveyance was not made as a gift, which would have fallen under the rubric of an attempt to defraud creditors. Rather, it was intended as compensation for the work she had done in caring for James Taylor and his wife, for her grandparents. At least so argued both her birth parents and siblings. More than 30 years earlier, around 1861, when she was no more than 1 year old, Ella Severs had been taken from her own parents by her grandparents, and she grew up and spent her life separated and apparently sometimes alienated from her birth parents and siblings. When more than 30 years later, the lawyers for Isaac Davis's creditors asked her father whether her grandparents had treated her as a member of the family, he answered, "Took her to serve and take care of them. They clothed her, they sent her to school, although witnesses disagreed for how long. According to her father, her grandparents pulled her out of school after 2 or 3 years because the old folks needed her to take care of them." According to several witnesses, the old couple had no servants in the household until close to the end. In other words, Ella had served her grandparents in their household, had substituted for the servants they had not hired. Ella's mother answered the question, who did the work in the house, with a simple answer. When Ella was large enough, she'd done it. What was the nature of the work? General housework, including the work upstairs. Her grandmother generally did the cooking when she was able, but when both of the grandparents got older, about the time that they moved into the house on Clinton Street, Ella had to wait on them. When her grandfather came down in the morning, he was a man that never could fasten his shirt, fastened in front. And Ella would always have to put on his pins and get his breakfast for him, to fasten his shirt all together and do everything pertaining to his needs. Her grandmother was much disabled. She was a very large woman. She also had rheumatism. She went upstairs all right, but when she came down, she would have to come down backward and have to be assisted. Ella's mother tried to expand about the care Ella had offered to her grandparents, but the judge stopped her. He did not think the quantum of care made any difference. This case was about whether there was consideration for the deed. As long as there was some work, that would be enough. An attorney testified about having drafted the deed in 1886. It was done, he noted, for the services rendered by Ella. But to Vice Chancellor Byrd, the judge in the case, the deed remained voluntary. That is, not founded on a contract. And therefore the deed could be attacked and nullified as a fraud on the creditor's rights. He came to that conclusion for 2 reasons. First of all, Ella, though she lived into her late 20s, had never been emancipated from her parents, from her grandparents, from the 2 people who had been the only parents she had ever known. The relation, the judge said, continued unbroken till her death. Perhaps he made things easy for himself by referring to Ella as James Taylor's daughter, not his granddaughter. But in the second place, he reframed the case through the lens of Disbrow v. Durand, a recently decided leading case of the New Jersey Court for the Correction of Errors. Byrd believed that this new case unequivocally confirmed the older doctrine about unemancipated daughters. But Disbrow looked at the question of compensation not in terms of patriarchal authority, but in terms of the expectations of members of a family living as one household. Within a household where people shared and lived together, it was, quote, the ordinary rule that such relationships abounded, quote, in reciprocal acts of kindness and goodwill, which tend to the mutual comfort and convenience. Work within a household was ordinarily gratuitously performed. Where such a relationship appeared, the ordinary implication of pay for services did not arise because the presumption that supported such implication was nullified. And such implication didn't depend, the court went on to say, on relations of blood. All that Ella had done for her grandparents belonged to a world of care and love. far removed from the colder realm of calculation and individual compensation, symbolized by a deed as payment for services. It didn't matter what her grandfather had said to his lawyer and to many others. It didn't really matter whether or not she was emancipated. She had been part of a common family enterprise, one that depended on the work of all, and she had remained within that household. The decision of her grandfather to convey the family house to her had been merely a gift. Now, as Vice Chancellor Byrd had predicted, Disbrow v. Durand became a leading case, invoked and quoted relentlessly over the next half-century. Byrd claimed that the opinion's significance lay in the ways it reproduced and continued an older understanding. But in fact, the opinion initiated a new style of analysis. In place of the need to invoke an authoritarian patriarchal family, lawyers and judges reimagined the family as a place of sharing. Those who worked to resist the claims to compensation of adult children now could reframe those children as people who were confused about what was and what was not compensable work. Adult children could be denied not because they were still children, but because they ought to have understood themselves as part of a family life whose premises stood in opposition to a separated world of work and individual calculation. So one default rule replaced another. McGill's notion of reciprocal acts of kindness and goodwill offered a new way to characterize how and why work occurred in families. And that new way reflected a growing recognition, certainly from middle-class lawyers and judges, of the separation of economically remunerative work from predictably smaller urban and suburban households. In the world reframed by Disbrow, blood and lineage became almost irrelevant for the question whether household work was compensable. Instead, courts asked, did you belong to the family or did you not belong? The household was becoming a site where remunerative work happened elsewhere, away from the household, except when a particular household became, for some workers, a site of work away from their own homes. That is, courts knew that there were some non-household members, nurses, housekeepers, servants, who came to a household because it was solely their place of work. For those strangers, those employees, including those who came to do care work, the household was not their home, and they had left their homes elsewhere to go do work in the household, and they would be paid. By contrast, family members belonged to the home, and they participate in reciprocal acts of kindness and goodwill. Now, the story that lay behind the actual case of Disbrow v. Durand encapsulated this emergent ordering and tells a really interesting story about what is the home in this context. Sarah Disbrow, the plaintiff in the case, was the elderly younger sister of Smith Noe. She was 72 in 1892 at the time of the trial. He was considerably older when he had died a couple of years earlier. She sued her dead brother's estate to be compensated for the 20 years she had spent keeping house for him in Rahway, attending to all the work of the house and caring for him. According to her attorney, Sarah Disbrow had only lived with her brother because of a work relationship, a relationship founded on contract. She had never made her brother's place her home. Her home was naturally with her son, and both he, her son, and his wife urged her to come to them. At trial, Mary Disbrow, Sarah's daughter-in-law, had testified about the work Sarah had done for Smith Noe. Housekeeping, washing, ironing, baking, churning, all the necessary work doing the housework. There were no other household servants, but there were other men employed by him on his farm, and she cared for their needs as well. She also nursed Smith Noe in his last illness, which lasted 3 or 4 weeks. Mary Disbrow, the daughter-in-law, had managed her own household ever since she had married Sarah's son 25 years before. So she qualified as an expert on what wages Sarah's services would have commanded in the local Rahway market. Well, I had to hire such help, and I had to give $12 a month, and I considered that not out of the way. It really ought to have been more, but she added that the pay scale would be higher if nursing were added. Sarah Disbrow's attorney had questioned Mary Disbrow whether Sarah, her mother-in-law, had ever resided in Mary's house. He wanted to get as close as he could to an evidentiary conclusion that Sarah Disbrow had another home with her son and daughter-in-law that Smith-No's house was not her real home, that it was rather just her workplace. Unfortunately, the testimony Mary gave did not help his case. "No, sir," Mary answered. "I wanted her, she could not come. I needed her, but she could not come on account of keeping house for her brother." Thomas Schaffer, the lawyer who represented the estate, took off from that response in his cross-examination. What family did Smith-No have? He had no family of his own. He was a single man. Who lived with him? His sister, my mother-in-law. Did anybody else live in the house? No, sir. A little while later, Schaffer returned to the same question. Was not Mr. Smith-No's house the home of Mrs. Disbrow? Didn't she make her home there because she had no other home? No, sir. Where was her other home? With her son. How long had she lived with her son? Answer, never. She could not live with him. She lived with Smith-No all the time. Yes, sir. Made that her home. Yes, sir. When Mary's husband, Sarah's son, testified that their house was always open to his mother, Schaffer asked him, who constituted Smith-No's family at the time of his last sickness? And the son had to answer, my mother and him. And that probably made it inevitable that his mother would lose her suit. Part of what must have made Disbrow into a striking result was the fact that it involved a suit by one sibling against the estate of another. In legal theory, siblings owed nothing to each other. The sibling relationship did not appear in domestic relation treatises as one of the domestic relations. Adult siblings were as strangers to one another, without enforceable obligations, free to contract or not to contract as the spirit moved. As adults, they did not belong to the same family. The core of what Disbrow meant for the judges and lawyers who looked to it and used it over the next half-century was that it provided a test. Those who lived together in a household presumptively dealt with one another as members of a common enterprise, one that precluded expectations of pay. The legal question posed was whether a particular caretaker was a member of the family or was she or he something else, that is, an employee. In 1907, to take a representative example, Annie Mullen married. Her parents were sorry to lose her, and they decided to work out a deal so that Annie would stay and take care of her mother, who suffered from rheumatism. They made a promise to the young couple that if Annie and her husband stayed, the place was to be left to her. Annie's husband, when asked what he thought of that, said he would have preferred to go to housekeeping, that is, for the new couple to have lived apart from her parents. But they negotiated, and there was an agreement that the new couple would not move to their own place. For the next 7 years, Annie Mullen's mother was able to move about the house on crutches and perform most, if not all, of her work. Then she fell and became more incapacitated. She could not leave the second floor, and eventually she became entirely helpless, unable to leave her chair, dependent on her daughter's care. After her death, her daughter, who was the administrator of her mother's estate, allowed herself $4,054 as payment at a rate of $30 a month for the continuous care she had provided between 1907 and 1918. She justified her allowance on the theory that she had been promised the house, and therefore she had moved in with a clear understanding that she would in the end be paid for having stayed. But when her allowance to herself was challenged, the Essex County Orphans Court invoked Disbrow. According to the court, until the mother's last 2 years, when the services she needed became equivalent to those that would otherwise have been provided by a paid nurse, what the daughter had done was to live and participate in a common household. And for that, there would be no payment, and the daughter's allowance was reduced to $1,500. Those who had cared for the elderly but who had not been paid as employees would have to explain why they had not been paid and why they had still continued to provide care. They could not rely on any presumption that work implied a promise, nor would a court presume that a non-relation or a distant relation was only there caring because of an expectation of pay. Members of families, related by blood or not, ordinarily dealt with one another without expectations of payment, out of love or friendship. Wouldn't be a commodified relationship. The language and moral vision of Disbrow then permeated the strategic choices made by lawyers who represented estates and heirs against litigants suing for compensation. Here's an extended example. what happened in 1915 when Julia Freen went to court after she was disappointed to discover that Cornelia Hudson had left her only a pittance. Julia had been Cornelia's companion for more than 20 years, and one might infer the love of her life. She had lived in Cornelia's household in Bayonne for more than 20 years, ever since she had failed her teacher's examinations in Staten Island, where she had grown up. It's the details. She was no relation of Cornelia Hudson. Her parents had been Cornelia's friends. After Cornelia's death in 1913, a codicil to her will was found to include a gift of $100 to Julia as an act of friendship which she is to forfeit if she sues my estate or heirs. Julia, who had expected much more from the will and who believed that Cornelia's son, Edward Hudson, had fraudulently inserted the codicil into the will, protested. Edward offered Julia $500 to pacify her. At first she accepted the offer, but later she repudiated it. And then she sued, asking for compensation based on 6 years' work as Cornelia's housekeeper and companion at $25 a month, plus 3.5 years of work as a nurse at $15 a week. A Hudson County jury awarded her $41.59. On appeal to the New Jersey Court of Errors, Elmer Demarest, the lawyer for the estate and for Edward Hudson, asked the court to reverse on the theory that the trial judge should have ordered a non-suit, that is, should never let the case go to a jury. His brief began by insisting that Julia had been practically a member of Cornelia's family and had always been treated as such by all the members of the household. Indeed, in a later passage in the brief, she was described as treated better than any member of the family. No closer relationship can be imagined between persons without consanguinity than that which the respondent, that is Julia Freen, admits existed between her and Mrs. Hudson. Julia, the brief continued, was no nurse. She was 59 years of age, lame, and had no experience as a nurse. She knew perfectly well that the services she was performing were given as though she were a member of the family. She was no servant. She ate at the table with other family members. She and Cornelia acted as mother and daughter. Julia understood herself as possessing an equal right in the household with other members of the family. What she did within the household, she did because of her affection for Cornelia. She might have hoped for a legacy, but she knew or ought to have known that the tenderness with which Cornelia cared for her should have been enough. At trial 1 year earlier, the work that Julia Freen had done for Cornelia Hudson had been described by a maid. What had she done? Helped do the cleaning, helped do the housekeeping, running of the house, everything except washing and ironing. And then after that, Julia sat with Cornelia. She did sewing and crocheting and all the mending besides waiting on Mrs. Hudson. She also went out on errands for Cornelia, who never left the house. The maid had overheard many conversations between Cornelia and Julia with regard to payment for services. Cornelia apparently often said she would give it to Julia if she had it, but she did not have it on account of her son, Ed Hudson, taking it from her. When he cross-examined her, Demarest had led the maid to describe how Mrs. Hudson and Miss Freen and sometimes Edward Hudson all sat down together at mealtimes. 2 next-door neighbors had added detailed portraits of the work Julia Freen did, including material on her serving at the table, clearing, dusting, getting rooms cleaned, cleaning the silverware, and taking care of the son's clothes and his dogs. On cross-examination, Demarest had asked the first neighbor if he had ever seen Julia do any work that a member of that family would not do. The second was challenged to justify Julia's claims that she did the work of a professional nurse. Cornelia Hudson's doctor had testified that he considered Julia to have been Cornelia's nurse and attendant. What nursing work had been necessary? He answered. Cornelia could not go upstairs or downstairs without someone with her. She was troubled with dropsy. That is, her limbs were swollen below the knees, making it almost impossible for her to get from chair to bed. I would not have considered her a safe woman, he said. Towards the end, she was not able to attend to her person. Most of the time she had control of her bowels, but not always. Then Julia attended and cleaned up. Julia, he had concluded, had been a good nurse, but he thought there had been much conflict in the house about the question of payment. Julia Freen had then testified. She too detailed all the work she had done. She did all the mending, and she would go out and do the marketing. She had expected to be paid for her time, but she wasn't, although she did receive $2 a week for taking care of Edward Hudson's dogs. After 1910, she had taken full charge of Mrs. Hudson's bodily care, bathed her every morning, clothed her and fed her, and she had had to change her bedding. Cornelia would often soil the bed. She did all the work usually done in an invalid's room. Demarest had reserved the right to object to her testimony, since it was an open legal question whether a plaintiff could testify in her own case. But then he cross-examined her about her treatment within the family. He had her walk across the courtroom to demonstrate how lame she was, too much so he implied to have been a real, that is, a paid nurse. She insisted she had been lame only for the past few years. They then went back through Julia and Cornelia's life together. She had been remembered at holidays with gifts, and she had given gifts to other members of the family, and she sat with them in the evenings. She was certainly no servant consigned to the back rooms. When Cornelia Hudson still traveled, Julia accompanied her, and they stayed in hotel rooms together. For years she had not been paid, but she did fancy work that she sold, and she paid for her own clothing. Julia described in detail all Cornelia's excuses not to pay her. Why then, Demarest asked, had she stayed? Because she never wanted me to leave her, and at last she was so sick I could not leave her. Cornelia Hudson was very fond of her, treated her as a member of the family, and she considered herself a member of the family. At that moment, one of Julia's two lawyers had Demarest repeat the question, presumably to give her, that is, to give Julia a chance to realize what she was saying, since all knew that a family member had no expectation of pay. This time she answered that she was only treated as a family member by Cornelia Hudson, not by others in the household. The services were performed for Cornelia alone. Demarest asked, "You considered that the services you were performing for her were as though you were a member of her family, as of her household, did you not?" She had answered yes. He repeated the question, then moved on. "Had Cornelia Hudson become like a mother to her?" "Yes, she was like a mother to me." "You had no mother, had you?" She had answered no. "The occasional spending money you received from her, you looked upon as spending money, the same as she would give to any member of her family?" Julia answered, "Yes, between ourselves." He pressed again. "You consider yourself, so far as she was concerned, a member of her household, did you not? Practically a member of the family, with the possible distinction that you were not a blood relative?" She answered no. She did not believe herself a blood relative. But she had felt on an equal level with the other members of the family because of what Cornelia Hudson was doing for her and what she was doing for Cornelia. Yes? At that moment, her lawyer tried to intervene on the theory that Julia evidently did not understand the question posed or the implications that could be drawn from the answers. The questioning went on. There was much conflict about money in Cornelia's last years. Julia tried to raise the possibility that Edward Hudson had forged the will. She insisted that Cornelia Hudson had promised to take care of her in her will. Demarest had then returned to the question, what had motivated her to remain and to care? Quote, "And up to the time you were rendering to Mrs. Hudson these services because of your love and your affection and friendship for her, the same as you had done for a number of years previous, depending upon her to give you at the time she died some legacy?" Her answer, yes, she always said she would. She had known she could not depend for support on the other members of the family. It was only when she found out how little she got that she became dissatisfied. Until then, she had never expressed dissatisfaction? No, because she, that is Cornelia, always said she would take care of me. Demarest, you felt that you were living with Mrs. Hudson, that she was doing as much for you as you were for her? Answer, she died in my arms. Question, but you felt that the tenderness with which Mrs. Hudson cared for you and the fact that she was giving you a home from the time you had been unfortunate was equal to anything you could do for Mrs. Hudson in return, did you? Her lawyer intervened again because the witness was a little upset, and one can presume he feared he was about to destroy her case for compensation. She took a moment to compose herself. Then she answered yes. One can only imagine the slumped shoulders of her own lawyers at that moment. On redirect, that is when her lawyers regained the opportunity to question her, they worked to reclaim ground. Under their questioning, Julia described how, in Cornelia's last years, her nursing services took up every hour of the day. She would be up several times at night, and there was no one brought in to relieve her. When had she become lame? Oh, when I was taken sick, and then when I fell working for her and doing. I was worn out working for her, and then I fell, and I've been lame ever since. It happened in 1911. How much had her fancy work earned for her? Answer, $40, earned one winter knitting sweaters. On recross, under questioning again from Demarest, for the other side, she admitted that if Cornelia Hudson were still living, she would not have sued. She had brought suit only because of the way she'd been treated by Cornelia's son. This, once again, could be read as a concession that she had no contract with Cornelia. But then there'd been one more set of questions from her lawyers on redirect. Why wouldn't she be suing if Cornelia Hudson were still alive? Because I expect I should be still living with her, kept right on taking care of her. She did tell Cornelia once that she would wait until she was gone, and then I would sue her. I said I would not worry you now. She was worried enough. Now, it's important to note, it's kind of an odd thing, that in spite of Demarest's apparently successful efforts during the trial, in spite of her own concessions that love had shaped her conduct and her identity as a member of Cornelia Hudson's family, Julia Freen won in the end. As is always the case, there should be applause at this moment, right? As is always the case, the written transcript cannot fully convey what the judges saw and the juries saw and what they knew to be true. And effective lawyering can only go so far. We can surmise that Julia's expressions of love for Cornelia did not in the end counter perceptions of the fundamental unfairness of the will Cornelia Hudson had signed, whether or not it was an expression of her intentions. Demarest's interpretation of the law that, quote, no contract to pay can be inferred from services when the plaintiff was a member of the decedent's family, was answered by the fact that Julia was not a relative in any degree. The evidence was not conclusive that the services that she had provided were intended as gratuitous. There was a fair inference to be drawn from the testimony that there had been an express promise to pay what the services were reasonably worth. And in any case, these were questions that could properly be submitted to the jury. Gradually, then, the Disbrow standard was confined to those who were living together as part of a nuclear family, exactly what the case had not stood for when it was first decided. Over time, the Disbrow standard, which seemed to suggest a broad and inclusive standard for who was a family member, that is, for all who did not need to be paid for family work, had narrowed. It had become easier for those who cared for older people within households to claim a right to payment because the New Jersey courts were willing to define those who did the actual work of care as workers, not family members. And over time, as a reflection of a moral and economic change, it became increasingly clear to the courts that old age care was something that ordinarily ought to be paid for. Was old age care still part of the work of a family, or was it becoming in its nature an exceptional task outside of the normal work that family members routinely did for one another? So, who were these 19th and early 20th century adult children, these younger people who sued estates for land or for damages, who insisted they were entitled to compensation or to property because of care that they had once provided older people in family homes? How to characterize those who inhabited this peculiar middle space, who were neither families nor employees, or both family and employees? Despite a legal culture ideologically committed to keeping home and work apart, where work meant pay and home meant something else, sometimes love, courts in New Jersey, as elsewhere in the United States, struggled to fix identities that were multiple and contradictory. Often it must have been as confusing for the adult children as it was for those who had to judge them. We can imagine that these adult children lived at the same time in at least two moral universes. In one universe, that of the family household, they earned rewards, moral and spiritual rewards, as well as material rewards, by sharing in a common family enterprise. The material rewards of having invested in the family might be frustrated. Older people, those in control of family property, usually did not have to act in accord with promises made. The property owner, the parent, the older person, retained the right to change his or her mind, to deny promised rewards. There was no legal duty to share, and the fights after death might have ruined the moral and spiritual rewards of family life at least retrospectively. But adult children earned rewards if rewards were earned by joining in, by being a loving family member. They justified themselves within that normative universe by showing exclusive loyalty, by submerging their independence as competent adults, by emphasizing their continuing place in the family, perhaps by continuing to be as children ought to be, even when they become chronological adults. It's one of the interesting side notes of this is that so many of my cases have the women in the case, the daughters, marrying right after the old person dies. So clearly there's some putting off of marriage until the very last moment. And then they all have, one of the reasons the names they have in the cases are always different because they've just married like days or hours after the old person dies. But obviously, as long as the old person is alive, they don't. In the other normative universe, a suit for compensation quantum merit articulates adulthood, that is, rights and identities as independent and contractually competent actors took priority. Subordination within a household was inconsistent with an adulthood that produced a successful cause of action, as was too much love. A good plaintiff's lawyer ordinarily worked to cabin a client within the second moral universe and to suppress the often multitudinous traces of the first. But as we've also seen, the complexities of real lives kept leaking out into the testimony, and that made the lawyer's work difficult. Revelations of sharing and caring and love could become destructive to the case the lawyer wanted to make. Remember the anxious interventions of Julia Freen's attorney as she described her love for Cornelia Hudson. But in the hands of a clever lawyer, cleverer than the one Julia had, it was even possible to turn testimony about how subordinated, how submerged an adult child had been into support for a successful right to individual compensation. Just as no individual or adult would have accepted the discipline of the factory floor without the expectation of pay, so it was with the adult child within the household. And one ironic consequence of subordination and loyalty within the family was that it sometimes could become implicit proof of a labor agreement between older person and younger family member. Someone like Julia Freen would not have stayed and done all that work, accepted a role as a dependent if she hadn't expected to be paid. For those on the other side, there were many ways, though, to mark adult children as greedy or ungrateful, that the younger people were morally obtuse or dishonest, forgetful of the primary moral universe in which they had actually spent their lives. Because of bad legal advice or because of their own moral deficiencies, these adult children had insisted on rights to property or to payment. They should have understood themselves as privileged to have grown up in or to have been part of loving homes. Or they ought to have recognized themselves as gift givers, not as crass contractors. They were people who had done good deeds as individuals in caring for older people. It sullied and darkened their moral status that they were now insisting on compensation for what they had once given voluntarily and freely out of the goodness of their hearts. Now, for adult children and their lawyers, there was only one effective counter to the charge that one was nothing but an ungrateful child. That was to describe in intense and often graphic detail the work of care. In almost every trial, testimony began with a description, usually by the plaintiff or petitioner, about the work she or he had done. And the lawyer would lead the witness through a description that emphasized what had made the work distinctive, exceptional, unusual, extraordinary, as something other than ordinary family labor. In doing so, lawyer and client were both marking the client's singularity and at the same time revealing the client as an autonomous contractual actor. Lawyer and client worked to connect the client's life to still widely shared and culturally resonant understandings, call them labor theories of value, that certain kinds of work done made a client singularly entitled to property or to the benefits of a promise. In 1899, to take one peculiar example, and those of you who don't want mess should leave at this point, Henry Cullen sued the estate of Asher Wolverton as the assignee of the quantum merit claim of David Lawshe. Lawshe was married to Wolverton's stepdaughter. he had called Wolverton father, and Wolverton had treated him, he said, as a son. And testimony in the case began with Lawshe on the stand to tell his story about the work he had done for Wolverton. Asher Wolverton may have been around 80 in 1893. In January of that year, on a cold and foggy morning, just a little while before church service time, he had fallen down a stone pavement and broken his hip. From then on, he suffered from chronic trouble with his bowels, requiring frequent injections. Only Lawshe was allowed to help him, and frequently, while Lawshe was giving him his injections, or enemas, Wolverton would say to him, "Dave, this is a very unpleasant job, and you shall be well paid for it." What had Lawshe done for Wolverton? Quote, this is his testimony. Either the second or the third day after this injury, a doctor gave Wolverton a physic to help him move his bowels. By evening, he was in distress because nothing was happening. And of course, I had to give him the injection in the bed. Lawshe and others arranged clothes under Wolverton beforehand so as to protect the bed as much as possible. But Wolverton was a nervous, fidgety man, so Lawshe had considerable trouble. Of course, he got himself pretty well smeared up. And of course, the result was that I got my hands pretty well smeared up. The same process was repeated every 3 or 4 days for the next 3 years. There was no regularity about just when the bowels would move after the physic was given. Eventually, the bowels began to operate on their own. After that, Lawshe would help Wolverton out of bed and onto the commode and then give him an injection. It was hard work to get him on the commode since his hip was broken. In particular, Lawshe had to get the rubber tube between his legs. He would have to, this is, it's amazing testimony to see how to read this stuff in a trial. He would have to, it's stuff I love, but I realize it's, he would have to use his hands to get the tube into the rectum, to find just where to place the tube in pumping in the water. Sometimes his bowels would break loose before you would be able to get the rubber tube removed, and of course the result was your hands would be in a pretty bad condition. Of course, sometimes you wouldn't be able to get away. How had Lawshe helped then? He'd get him back into bed after he was washed and cleaned. I would stand him up and clean him in that position, standing up alongside the bed. Did he ever cleanse this person by passing your hand in under him between his legs as he sat on the commode? Yes, sir, I've done that. Meanwhile, Lawshe also looked after Wolverton's farm and his quarries in Hunterdon County. He would get things for the household from the farm, potatoes, apples, and chickens, and he also shoveled snow for Wolverton. Now, what was such testimony supposed to prove? The simple answer is that it demonstrated that David Lawshe was not doing what a neighbor or a friend or a household member ordinarily did. He was doing something peculiarly repellent, something that a man certainly, but a woman too, would have been unlikely to do without a pre-existing understanding. Because of the exceptional nature of these tasks, because of exceptional labors, he became something other than a member of Wolverton's household or a friend or neighbor. As the judge put it at the end of the trial in charging the jury, if what Lawshe had provided were mere neighborly services that one man would render to another, then there could be no claim. But that was certainly not the case here. And the jury gave a verdict for the plaintiff for $975. From the earliest American case where a court ordered a performance for a promise for care, an 1846 New York case brought by one brother for the care of a brother subject to epileptic seizures, exceptional tasks or labors were mobilized to justify a right to compensation. In quantum merit cases, as in David Lawshe's case, the exceptional provided an explanation why one was entitled to something more, to compensation in ways that differed from the ordinary compensation for having lived as a family member. The exceptional moved the description over into the second moral universe, the universe of contractual obligations, and away from the first, the universe of family love. The exceptional also solved the problem of proving an underlying oral contract. Tasks that were exceptional, like those undertaken by David Lawshe, were not ones that could be explained except through the lens of contract. Ordinary and routine household duties, ordinary and routine care belonged presumptively to the realm of Disbrow's reciprocal acts of kindness and goodwill, which tend to mutual comfort and convenience. Not so when care became intense and personal and arduous, when older bodies and minds fell apart. Now, over time, some of the seemingly ordinary and routine work that women did, housework and nursing, gradually became tasks presumptively subject to market standards of compensation. That is to say, over time, more of the work that women did as members of the households of others, whether their parents' households or the households of employers, became understood as exceptional, unusual, unexpected, explainable only through the presumption of a pre-existing agreement. The starting premise in the middle of the 19th century had been an understanding that housework was just that, housework, all of a piece. Unless previously specified, there was no reason to distinguish one part of the complex whole that was housework from another. And women who did the work for pay were expected to adjust to shifting demands and tasks as the needs and the demands of the household changed. For most women, indeed, ordinary nursing was understood as a part of the package of goods and services that were incorporated into the generic term housework. Although what was ordinary and what was extraordinary was a matter of continuing litigation. Nursing was both a general skill peculiarly identified with womanhood, and by the end of the 19th century, it was becoming a distinct skill that had a clear and growing market value. One result was a good deal of conflict over the rights of married women to charge for nursing services. In Gerritsen v. Appleton, 1895, one case among several where a wife insisted on compensation for nursing she had provided within her, or more properly, her husband's home, a wife brought a claim against an estate for nursing services. Peter Van Pelt had been the landlord of her family home in Perth Amboy. He had moved in with them in 1891 to get a kind of attendance or care he could not get at his own home. The nursing Christina Appleton provided was, all agreed, arduous, exacting, and sometimes of a repulsive character. She was, according to an attending doctor, an excellent nurse. Van Pelt's dropsy meant that his testicles had swollen to huge dimensions, as big as a small muskmelon and as black as ink. His scrotum and testicles needed constant washing and bandaging. She had to get him out of bed and to and from the stool. She used a liniment on his sores that his doctor gave her, made of alcohol and red peppers that burned the skin off her own hands. What she did, according to another doctor, was worth around $3 a day. And after trial, a jury awarded her $964 for her labor. The problem the case raised was that Van Pelt, the husband, had made a Van Pelt, the person taken care of, had made a bargain with Christina Applegate's husband when he had first moved in with them. The contract, according to her and her husband, was only for board, meaning there was no agreement about nursing. But according to the other side, according to those who represented Van Pelt's estate, the bargain had been for both board and nursing. Since he'd moved in with them because he was not receiving appropriate care in his own home, it seems unlikely that nursing was not contemplated. In light of that bargain, could she bring a separate cause of action apart from her husband? According to Christina Applegate's lawyer, it was appropriate that she bring this case in her own name. The husband had done no nursing except for occasionally helping to move the old man from bed to stool. He was an oysterman and boatman, not a woman, not a nurse. But such facts were quite irrelevant, according to the defense. What she had done, the services she had rendered, were in the discharge of her duty as a wife, and thus were incorporated into the contract Van Pelt had made with her husband. A wife's right to her own earnings under the new statutes that limited coverture were restricted to those that derived from a regular calling, and nursing in the home was not such. More, according to the defense, her husband had signed an agreement that we would bring no claim against Van Pelt's estate. When the husband was asked on the witness stand whether the we meant that the wife accepted and signed as well, he answered, "No, sir, I never consult my wife about my business matters." And he insisted that the we was a simple mistake. Christina Applegate had apparently believed that Van Pelt would leave her the house and lot on which they lived. She was, as such, speculating on a legacy. And what she had done for Van Pelt, if viewed as outside or beyond her marital duties, was properly understood as gratuitous and voluntary, not compensable. Her services were at most or at best a gift she had given to Peter Van Pelt. Over time, though, nursing, which had long been understood as an undifferentiated part of the package of services that women as employees and as family members provided became a specialized task, became separately compensable work. The care and attention that disease and decrepitude and dementia required were less likely to be viewed as predictable and ordinary family responsibilities. Nursing as such belonged to a labor market, and it could be measured and paid for with reference to that market. And nursing and intimate bodily care gradually ceased to be tasks that daughters and younger women and ordinary domestic servants generally expected to assume as part of the unspoken understanding of their jobs within households. By the post-World War II world, the ordinary activities involved in staying home to care for demanding elderly people, cleaning, cooking, comforting, were themselves becoming understood as exceptional in their nature, not as normal things to do, even for daughters or daughters-in-law. Such activities presumed an underlying understanding that compensation would be paid. That is, courts were learning to view the undertaking to care for an older person as carrying with it a presumption that it must have been an undertaking premised on a promise to pay. And one might say that is the end of the story. The older understanding that work within the home constituted an exception was apparently no longer operative. Claimed promises that once seemed unproven or unprovable or legally uncompelling because they were made to a younger person who was doing what a younger person was expected to do had now become more believable and more legally compelling. Thus, in 1952, a daughter-in-law's claim that she'd been promised to pay for the care she gave to her husband's parents over most of 2 decades seemed entirely believable to the New Jersey Superior Court. Soon after her marriage in 1933, she began going to the apartment of her in-laws where she did the housework, shopped for the couple, cooked their meals, and acted as their practical nurse. Both in-laws were overweight and sickly, and the daughter-in-law cared for them and their needs throughout the day. Those who resisted her claim had argued that the plaintiff was a daughter-in-law, and the services she had rendered must have been offered without expectation of compensation. The court made short work of that argument. The court worked to distinguish the facts in this case from those in Disbrow. The daughter-in-law had lived with her husband in their own apartment, unlike the sister in Disbrow, so she had a separate residence and was not technically part of the same household. But the case also carried the inference that the very fact that she did so much work for her in-laws suggested that the in-laws must have expected or had led her to believe that they expected to pay her. If she wasn't expecting to be paid, she wouldn't have stayed to work and to care. No one, certainly no daughter-in-law, would have done so. As of 1952, then, we are not yet in the America familiar to us in the early 21st century, where direct care of the decrepit and more or less helpless old is presumptively paid by way of paid contracted work by strangers, many of whom will be employees of large corporations, health providers, nursing homes, or insurance companies, among others, or of governments. We are not yet in a normative universe where the needs of the old will be serviced by global armies of migratory workers who do aspects of the work of care that most family members no longer imagine doing. But we are entering a normative universe where the default rules had changed. In the post-World War II world, direct care of the old was not something done presumptively out of love or guilt or habit or sense of duty. Which is not to say that there were not many who would not continue to do for others, to care out of love or guilt or habit or sense of duty. But in the courts, in the law, care work for the elderly was increasingly understood as belonging to a commoditized universe of pay for services. And yet, as my conversations with my sister and the classes she took at Stony Brook revealed, nothing was really settled. And we still today feel the pull of competing and contending normative universes. Family work is still incompletely commodified. Adult children remain uncertain what they owe and what they are entitled to. Thank you.